the decision was a complete repudiation of the Trudeau government's position. And they just lost on every possible measure here.
Welcome back to Northern Perspective, everybody. As most of you know, last week a ruling dropped from the Federal Court of Appeal that upheld Justice Mosley's decision that the federal government acted unconstitutionally when invoking the Emergencies Act. And the only reason they had the opportunity to do that is organizations like the Canadian Constitution Foundation brought that fight to the government itself. And joining us today is the litigation director for the Canadian Constitution Foundation, Christine Van Geyn, who has her own YouTube show, which everybody should check out. And we will put that link in the description at the end of this video. But Christine, welcome to Northern Perspective.
Thanks for having me on.
Okay, so this was an interesting ruling that came down because I think there was a lot of Canadians that were skeptical as to whether or not the Federal Court of Appeal would uphold Justice Mosley's ruling. I think in the initial ruling, a lot of people were skeptical whether or not the ruling would go that way. What was your take when your organization got the news that the Federal Court of Appeal upheld that?
Yeah, I mean, obviously we brought the case, so we're ecstatic with this ruling. It's a unanimous decision on behalf of the court. So we thought maybe there would be a dissent. I understand the skepticism of a lot of Canadians because, look, this law has never been used before. It's never been interpreted before. We don't know what's going to happen. So we're all kind of, I think we had a strong case, and obviously we did, but you don't know what's going to happen with a law that's never been interpreted before. But the decision was a complete repudiation of the Trudeau government's position. And they just lost on every possible measure here. So obviously we're ecstatic. We think this is amazing news for civil liberties in Canada. This is a decision that's going to be taught in law schools. And what we really wanted was when a law this powerful and this extraordinary exists, the Emergencies Act is a very powerful tool. We want it to be interpreted through a lens that values liberty. And that's what we got here with this decision. So we're happy with it, very happy with this decision.
And one of the core aspects of this whole thing, and I believe, if I'm interpreting the CCF's argument clearly, is that all of this relied on essentially one aspect, which was what is the definition of a national emergency? And it's pretty clear when I was reading it in the Emergencies Act, it defines the national emergency as see the CCF Act. And then if you go to the CCF Act, there is nothing in there about economic harm, which is what the government was trying to base their whole invocation of this invocation on. Is that a fair characterization?
So let me explain it sort of how we argued it, which is there were three main issues: that whether the threshold to use the act was met, and that's the part that you're talking about. And then once the act was used, whether those regulations that froze bank accounts and banned assemblies were unconstitutional. And the government lost on all three. But on the first issue, the threshold to invoke the act, there are, as you described, these statutory requirements. So there must be a national emergency, and that has all kinds of different components. So yes, part of the component is that there is a threat to the security of Canada, which includes, it's defined by reference to the CCF Act. It also, though, requires that there is an exhaustion of other legal tools. It's what we call the last resort clause. And what the court found in this case was that provincial tools had not been exhausted. That's another part of the threshold. The provinces actually didn't want this to be invoked, aside from Ontario and Newfoundland were okay with it, but Alberta objected, and so did other provinces. And another part is the existing legal tools. And for example, the criminal law exists and it could be used. And our CMP Commissioner, Brenda Lucky, said that existing legal tools had not been exhausted. The court cited that. And then, of course, this idea that there is a threat to the security of Canada, which is defined in the CSIS Act. CSIS said there is no threat to the security of Canada. Cabinet said, well, we have different inputs. We don't need to reach the same conclusion as CSIS. That's true. CSIS isn't the decision maker, Cabinet is, but the decision needs to be reasonable. So if Cabinet is going to depart from CSIS's interpretation, CSIS is the one who has access to all this information about national security, by the way, and has a deeper understanding of it than Cabinet, as they are the ones on the ground. If Cabinet's going to depart, they need to give have reasonable grounds to do so. And the court said that they didn't hear. Cabinet did not have an additional threat assessment prepared. And in fact, what they argued was that economic harm is the same thing as violence towards people or property. So a blockade is the same thing as, for example, burning down a building or killing someone. And the court just flatly rejected that. They said that this would have dire civil liberties implications because it would justify prohibiting all kinds of public demonstrations. For example, labor strikes would be prohibited if it was just economic harm that justified invoking the Emergencies Act. So, really, a complete repudiation of the Trudeau government's attempt to give novel meaning to the words that many, many statutes use, which is threats to the security of Canada.
And the other thing that jumped out to me in the court ruling was when the Federal Court of Appeal referred to the fact that when the RCMP was ordered to execute the search and seizure, that there was minimal, if any, pushback or demand for justification of reasonableness in there. When you were reviewing, the initial facts of this case, did that surprise you, or when that was brought up in the public inquiry on that?
Yeah, so I think what you're referring to is one of the other issues in the case, which was the standard for freezing bank accounts. So once the Emergencies Act was invoked, Cabinet created these new criminal measures, these new regulations that essentially deputized banks as agents of the state, gave them an ongoing obligation to continue to provide police with private, confidential financial information of who the police called designated people. And we argued that this sharing of information, of private financial information, was a violation of the charter right to be free from an unreasonable search. And the court found that it was. This was compelling banks to share private financial information with police without a warrant, without notice, without recourse. The court found that the system for determining who was a designated person had no procedural safeguards, and it was based on subjective belief. When you read the decision, the court noted that the police told banks who they wanted information about, but beyond that, to comply with the ongoing obligation to provide police with information about the designated people, banks were told by police to leverage social media and the news to identify suspects. So the banks were expected to, scroll on Twitter to see who looked like they might be involved in the protest and provide the police with their private financial information, which could then be used to charge them with an offense. All done without a warrant, all done without recourse. So this was a search, and it was an unreasonable search. It was a search that could not be justified under the charter. And, the court found it was an unconstitutional act. And we, of course, agree.
Now, to try and take some of the partisanship out of this, a lot of people will probably say, well, this is just a bunch of, right-wing conservative people, and this is a left versus right issue. But just to clarify for Canadians, this decision, is this a left or right issue for the Canadian Constitution Foundation, or is this a broader civil liberties issue? And assuming that's the case, what could be some of the dangers, even for people of all political stripes, if this were actually struck down at the Federal Court of Appeal? What precedent would that set?
Yeah, so I absolutely despise when people try to make civil liberties issues a partisan issue. So our fundamental freedoms don't belong to a particular political party. They don't belong to the right. They don't belong to the left. Governments of the right trample on our fundamental freedoms. Governments of the left trample on our fundamental freedoms. And we see partisans on both sides who call for violations of our freedoms. So I think that it's important for nonpartisan organizations like the Canadian Constitution Foundation to stand up for these as principles, not for any particular partisan game, because this is authoritarian conduct can happen from any government. And in this instance, it was from the Trudeau government, but I expect any government can engage in authoritarian conduct. So, no, it's not a partisan issue. It's a civil liberties issue. As for why people on, for example, the left should be concerned about this, because this protest was seen as a protest movement of the right. And what I want people to remember is that this case is not actually about what you think of this particular protest. You can agree with the protest, you can disagree with the protest. The point of our Constitution is that it guarantees the right to free expression and the right to be free from an unreasonable search, and that this Emergencies Act, which gives really extraordinary powers to cabinet to create new criminal law, that is a power, an executive power that needs to be constrained by the words of the statute. And we don't want to hand huge grants of authority to our executive without the possibility that it be judicially reviewed. And that's essentially what the Trudeau government had been asking for here. So it's not about what you think of the protest. You can disagree with the protest, but still think that invoking the Emergencies Act was wrong. Because if you have your own protest that you think is a cause that you believe is worthy, you don't want the government doing this to you. You don't want the government freezing your bank account because of a protest that took place on the steps of Parliament. That is frighteningly authoritarian conduct.
So now that the Federal Court of Appeals has found this situation to be unconstitutional, where does the liability rest? Is it with the government? Is it with the banks who were seizing people's accounts? Is it with the police? Who is it with?
So, the main outcome of this case is that future governments facing political tumult will not in the future casually reach for emergency powers to solve a domestic protest. That is the most important outcome. Now, in terms of liability, I'm asked this all the time because people want accountability for their government. What I would say is that people whose accounts were frozen, for example, or who experienced an arrest and some abuse in the conduct in the course of that arrest, they were already able to bring a civil claim for that, and many of them did. I'm friends with some lawyers representing some people who were unlawfully arrested or who had their accounts frozen. If they can show damages, they have brought claims for that, and they can sue the government for damages. As for one of the things I'm asked all the time is, can Justin Trudeau be sent to jail for this? Can Chrystia Freeland be sent to jail for this? That's not how our system works. We don't put politicians in prison for official acts of the crown, which is what this was. This was an act of the crown. And now, certainly, it was a mistake. It was done in a way that shouldn't have happened. But we don't put our political leaders in prison because even if they made a very bad mistake of the law in the course of doing their official duty, because I mean, it does happen that politicians do things wrong. We are not a country that imprisons our political leaders once they're out of office. And I don't think that's the direction that we want to go. I understand the frustration many people have that there isn't, a personal consequence that our politicians bear for that, but that's not the system that we live in.
And that's a fair point, because again, looking at this more broadly, if let's say we did, because I've often thought, should there be consequences, legal consequences attached in the future for a government wrongly invoking the Emergencies Act? Um, to your point, what precedent would that set in Canada, and would that allow future governments to put political opponents in jail for just those reasons? And
Yeah, we don't want to go down
is
that path.
right,
Exactly.
right. So that's the broader concern. Um, if the Canadians that were affected can somehow be made whole, or at least get some sort of restitution through taking civil action through this, that's hopefully that will be enough for folks
And
going
they're
forward.
already they would have already brought those claims. This
Right,
decision would help buttress those claims.
right. Now, do you think the fact that Justice Mosley put forth such a lengthy and detailed argument for in his decision, the fact that the Federal Court of Appeal unanimously struck down all the government's claims and upheld Justice Mosley's decision, do you think there's any reasonableness for bringing a further appeal by the government to challenge this in the Supreme Court?
I mean, the number one reason that people appeal a decision is because they lost. The errors are kind of secondary to that. If the argument that there's some mistake in the decision is secondary to the loss. So I am certain that the advice that the prime minister will be getting from the bureaucracy will be to appeal. We of course would prefer if they don't appeal. We think that this is a really well reasoned decision. It will be really hard for the government to overcome two losses, including a unanimous loss. And, um, you know, they have 60 days from the date of the decision to announce their appeal. And then it's up to the Supreme Court to decide if they want to hear it or not. Um, we are preparing for the government to appeal to the Supreme Court because we need to be ready for that possibility. We'd obviously prefer if they don't. So if any of your viewers want to support us in the event of an appeal, they can make a tax-deductible charitable donation at the ccf.ca/donate. We are only able to do this civil liberties work fighting for Canadians' fundamental freedoms because of the generous work of our donors. The government spent over $2.2 million. We are the perpetual underdog. We spend a fraction of what the government spends. And, we civil liberties cases are hard. It's not often that we are successful the way we were in this case. So it's really important to uphold this decision. So please, if you agree with what the outcome was in this case, please help us to fight an appeal if it happens by visiting the ccf.ca.
Yes, because folks should understand this is not the only case that the Canadian Constitution Foundation is involved with. I believe you're also involved in the forest ban case out in Nova
Yeah,
Scotia,
that's our case as
as
well.
well as several other cases that are ongoing. Correct?
Yeah, so we do a lot of freedom of expression work. We're challenging municipalities across the country for unconstitutional laws, for censorship laws. We're monitoring the federal government's work on C9 that would vastly expand the criminal law's scope to regulate speech, including religious speech. We're really concerned about that. We're involved in a case headed to the Supreme Court in March about the notwithstanding clause. It's a really important issue. That's going to be another case taught in law schools. It's a generational case about the interpretation of Section 33 of the notwithstanding clause. So we're very busy. And for the size we make a really, really big impact. We're a lean and scrappy little team that it manages to hire some of the best lawyers and have some of the best civil liberties victories in the country.
Now, speaking of that, you were called to the bar, I believe, back in 2012. Is that right?
Yeah, I think so.
We try to do our homework, and you became litigation director with the CCF in 2020. How did that all come about?
Yeah, so I worked in private practice for several years. Then I left to join the nonprofit world. I was a lawyer with the Canadian Taxpayers Federation for a while. We were involved in some constitutional challenges related to the carbon tax. So that was a fun place to work. When I went on maternity leave, I was approached by the Canadian Constitution Foundation and asked if I would consider joining. And this was at the end of 2019. I said yes, not knowing that 2020, few months before I joined, we would be in the middle of a global pandemic that led to some of the most historic civil liberties cases and policies that I have ever seen in my lifetime. So that was a really, really exciting time to join the CCF. At the end, we ended up doing a significant amount of COVID era litigation, really kind of nuanced and specific litigation. We really wanted to take on cases that we thought had a chance of success. At the end of that whole experience, I ended up writing a book about the civil liberties cases that came out of the pandemic called Pandemic Panic: How COVID-19 Changed Civil Liberties in Canada Forever. So that book's available on Amazon. If you want a really in-depth understanding of what happened to our civil liberties during the pandemic, it is probably the best resource that's out there.
Amazing. Well, on behalf of all Canadians of all political stripes, thank you to you and your organization for continuing that fight. To your point, these organizations are so essential because it's not just a left and right issue. This is a government overreach issue, and governments of all of all levels sometimes go too far. And this is where we rely on civil liberties organizations like yours to advocate on the behalf of Canadians, because otherwise Canadians probably wouldn't, and they wouldn't know how. So it's up to organizations like that. So so thank you so much on behalf of everybody. This is I think one of the most important wins in civil liberties in recent memory because of the effect of the Emergencies Act. But where else can Canadians find you or the CCF other than ccf.ca?
Yeah, so I'm a very busy lady. I also have a YouTube channel. You can search the Canadian Constitution Foundation on YouTube. I also have a podcast called Not Reserving Judgment, where we talk about interesting developments in Canadian constitutional law, and we give our bad legal takes of the week, where we describe legal opinions that didn't quite land, where some public commentators got the law wrong, but still told everyone what they thought about it. And I also have several books available on Amazon, including a new children's book about freedom of expression called Maple's Garden. So lots going on in my little office here in Toronto.